Now folk, this is 13I. The previous one was 13H. 13I. The north-south interconnector. What the options are, okay? So we're just continuing on, and I think these videos are not going to help my channel. I think people see it as a bit of an old schoolmaster preaching, but it's important, and it is, you won't get this stuff anywhere. And I do have great time for the great people that have helped in this. I'm so sorry for them to see those blasted pylons going over their houses. But a lot of them deserve them. A lot of them are getting what they deserve because they wouldn't have the courage to allow me and others to speak. And people who have put so much effort into obtaining rulings from the United Nations Arts Convention Committee to condemn Ireland for this, and have done so much, and they wouldn't listen. Essentially what a lot of them wanted, they wanted the windmills and they wanted the pylons on the ground, and they thought they were going to get that. And that was a silly, stupid thing to do. A lot of the landowners up there in Meath, there was 87 wind turbines going between Kells and Trim. But greedy landowners that have good land and don't need this, and they were going to plaster the whole place with it. And there was great protest put up, and it was eventually refused. It was element power. And so the question arises, how could North East Pylon justify being against the visual impact of the pylons when they had no problem with big turbines 126 metres high? It did not add up. It did not add up. And they thought that the local politicians had put them underground, and that is baloney, because the project of common interest specifically says that to go overground. That's set in stone in Germany unless it can be challenged in the court. So now we look at the National Renewable Energy Action Plan, and we look at what was not called an SEA. The National Renewable Energy Action Plan was implemented in the summer of 2010, and I don't think it was called an SEA at all. It was just a kind of an old rubber stamp thing. But they only allowed 10 days for the public consultation, and the Maastricht recommendations and all the other ones takes longer. It's 5 weeks in Ireland to put in your submission, and they only allowed 10 days. And the second thing is that there was only 3 private submissions right on task, and some of them were all notified, and they put in a big thing. Oh, it's a great idea, but no private person put in a submission except there was 3. I think I don't think they were on that one, I'm not sure, but there was 3 submissions made only by the public. It went on, and I never knew a thing about it. They're supposed to have a big notice in the paper. They're supposed to put it out on the radio, have a notice in the mart, and a notice around the country. The same as Planning Commission. The public are supposed to be told in the same way. There's a newspaper notice and all that. Now, at the time, probably no one would have taken part, but I certainly would. There was a few of us probably would. So they didn't notify it. But there was a bit of apathy and a bit of ignorance by people. At the time in 2010, I was struggling to get to grips with this law. But I can't understand if someone does get to grips with it, that nobody should listen to him. So there's only 3 private submissions. And they put in all this 5,000 kilometres of cabling, and there was, I think it was 4,000 wind turbines, and all this glowing stuff, how wonderful it was all going to be. All just drafted up in an office. There was no public consultation worth anything. There was no submissions worth a damn, except 1 or 2, and they weren't prepared to listen anyway. And there was no judicial review taken, because an SEA must allow for judicial review. Now, Grid 25 then came on, a kind of a refining of the pylons and the grids for the country. And there is provision in the SEA directive for a modification. You don't have to do it all in the one. You can add on a modification, but whatever you know about at the time you do it should be in. It should be as comprehensive as possible, but you can add on pieces to it and put it through the same system. Now, I know this is confusing some people, and I'd say by this time I'd be lucky to have 5 people staying on watching it, but I'm doing this because I have to try and explain it. Now, I also make the point about the liability for this information. I can't be held liable. This, if it went wrong, could cost people money, and I can't take responsibility for anything except what I do myself. Now, should should be a notice in the paper and notices on the radio. It should be advertised properly. And in recent years, with some other ones they did, on other things, there was notices in the paper. They were in the Farmer's Journal. They'd be about 6 inches by 6 inches, and they were in the paper, and they were there. Usually there were things that weren't controversial, and they probably got no submissions. But this energy thing is a totally different thing. This is a transformation of the country into a hedgehog. Now, I've said how in the National Renewable Energy Action Plan, the main plan and programme, and Grid 25, which was a modification of it, there was another one done for Grid South. It was the second one. And there was 35,000 submissions to it. So central to the case for to challenge the pylons would be that the National Renewable Energy Action Plan was not assessed under the SCA directive, and there was only 3 people made submissions, and the same with the Grid 25. And yet when they did it right and when it became known, there was 35,000 submissions. That was put before Judge Max Barrett, and he chose to ignore it. So that's how you'd go in. And remember, you're out of date after 8 weeks. So how do you challenge it? Well, you challenge it, in my opinion, under Section 160 of the Planning and Development Act right now, on the basis that the European Court has clarified in the judgment C-2419 that if they're built in contravention of the EU law, out they have to come. Now, there'll be a queer tussle for that when that comes on. And if that happened for the pylons, it'd be lovely, it'd be a great idea. Will it happen? I don't know. Now, the PCI regulations are, you get them on the internet, you go PCI Regulation 347/2013, made on the 17th of April 2013. Now, I'm going to get my computer up to show you a few things about that, because what they say, a whole lot of rosy thing, how wonderful it is, and there's a list, and the pylons are on the list, the North-South Interconnector is on the list, and it's there for wind energy, which could be challenged. So you could challenge it on the basis that the wind energy guidelines are not assessed, are not legal, and you have to watch, because if you challenge on something that's too remote, that's too far away, the court might not agree. Now, in any challenge, you'll be going into the High Court, and almost definitely the Irish High Court will throw it out. You'll have to appeal to the Supreme Court. No other way. And the Supreme Court will give a much more high quality judgment. Now, you could be lucky and meet a judge that say you're right, but I don't think so. And if you win in the High Court, EirGrid will almost certainly appeal to the Supreme Court anyway. So if you're getting lawyers, you have to assume you're going to the Supreme Court, full stop. The Supreme Court could rule in your favour, or it would probably refer it back to the Court of Justice of the EU, and it'll go over there. And what happened in this case was they were backed into a corner. They had to either say that guidelines were not part of a plan or programme, in which case they'd have destroyed the whole concept of the treaties, or they had to say they were, and they said they were. Very, very simply, and they said if you're challenging one that's up already and the lights are going to go out in a country, you can hold off for a little while. Either do the SCA, which they can't do. Now, they might try to do an SCA. My God almighty, we're ready for them. There's about 50 people in this country that will tear the eyes out of them. And I personally prepared to go in. I'll challenge them all the way. And we probably would get lawyers and all, and those lawyers will probably take it up. So they're going to get it very hard to do in the CA, because we can show the wind energy doesn't work. It's a complete scam. We can show it's saving no CO2. We can show the birds it's killing. We can show from the information, we have all the data all gathered up, what can be done. And so we all won't be dying too early. Some of us will survive. There's 8 or 9 people in my group that will challenge them. They'll not do the SCA. They told people that friends of mine, that they won't do it, that they have no plan B, they're hoping it'll never be challenged. And now it is challenged. The SCA directive is full law. It's the same as a pub. You have no licence on the pub, you can't be charged for having people after hours. You have to be charged with running an illegal pub. We're on 9 minutes. So you can look up the PCI directive yourself. And now I'm going to get my computer here going, folks, and I'll just pause for a second because I want to show you something. Now I have my laptop up here and I have the PCI directive on it. And I'm going to read you bits out of it. So the first thing I need to look at, I might have to stop here again. Now the PCI is a regulation. If I said a directive, very sorry, it's a regulation. It takes effect immediately. And the question should come to your head. How can a crowd in Brussels, the EU Commission, do order a PCI and a whole plan be put on for building this interconnector and all this infrastructure outside of the SCA? And the answer is they try to fudge it. And I'm going to tell you why. And you notice I put a 31 down here, and you can check that yourself. And I'm going to read you the preamble. In a regulation or a directive, you get a preamble, which gives you the soft talk. And then you get the articles, which are the hard law. Okay. So what it says here now is, and I have it listed here in this, the correct coordinated implementation of the Directive 211/92 EU on projects. Now this regulation is saying, get your finger out, put a whole lot of things on the list, and we'll give you funding, and away you go. So how do they get around the SCA and the EIA directive? Are they saying that you don't have to bother with them? If that's the case, the EU Commission is acting outside its powers. It's in contravention of the Treaty on the Functioning of the EU and the Lisbon Treaty, and the European Court cannot allow that. It cannot allow that. If it does, the entire EU is finished. It won't happen. And when the wind farm guidelines were put to it, they didn't do it. They went with the treaties because they know that would bring them down. I'm just checking the time here. I have a light over here and it's in my eyes. It's just a bit hard to see. Now, so I'm going to read what they say here again, but I'm going to cut out a lot of waffle that's not necessary, not relevant. The correct coordinated implementation of the EIA directive of the European Parliament and Council of the 13th of December 2001 on the assessment of the effects of certain public and private projects on the environment. 1. 2. Of Directive 201/42/EC of the European Parliament and Council of the 27th of June 2001 on the assessment of the effects of certain plans and programs. The EIA refers to a project. This is a plan or program on the environment where applicable, and it then goes on to say the Aarhus Convention and the Espoo Convention on transboundary, and of course the pylons goes across the boundary. And I challenged them that they didn't do the transboundary assessment. There was no real assessment done, and of course Judge Barrett threw that out as well. He wasn't interested in listening. Now, so transboundary should. Now this is where the correct and coordinated implementation of the SCA directive, I'm cutting out the rest, should coordinate their assessments for projects of common interest and provide for joint assessments where possible. Member states should be encouraged to exchange best practice and administrative capacity building for permit granting process. That's all the reference there is to the SCA directive. They were caught. They couldn't get round it, and they waffled. That's what they've done. Here it's again for you. Have a wee look at it there. The correct coordinated implementation of Directive the EIA directive for projects, and of the directive, here it's here. Yes, Directive 201/42 EU. Say that again. We can take down this bit here. The correct coordinated implementation of the Directive 201/42 EC the Aarhus Convention, the ESPO Convention on the Transboundary, the harmonisation of the main principle of assessment of environmental effects. All happy talk. Joint assessment, best practice and priority planning. That means going direct to Burplanola. Now, I have no problem going to Burplanola. I have always said you can't expect Cavan, Monaghan and Meath County Councils to assess the pylon separately. They're one big project. They'll be going to Burplanola anyway. A lot of people take exception. Oh, you're wrong in that. I'm not wrong on that. That part of it is not against the law. The EU does not insist that you have to have the local planners. But the point is, if you have an ordinary project like a quarry, let's say, you have the local planning, Meath County Council. You have a Burplanola to which you can appeal to, and then you have the High Court to which you can appeal to, and the European Court of Justice on the directives. Okay? When you take out the local councils, Cavan, Monaghan and Donegal and Meath, you only have Burplanola. And therefore the right of appeal to the High Court is more important. You just get one bite at Burplanola. And then you have the High Court. And that's why anyone like me, there was only two challenges to the pylons. There was NEP and there was me. And I should have got treated properly by the courts. I put a good case, I knew the law fairly well, and I should have got a better deal than him just saying that the Burplanola is only a clearinghouse with no substantial decision to make. And he totally ignored the fact that there was no proper cross boundary. The people in the south are supposed to be able to be notified of the assessment in the north, and the north is supposed to be notifying the south of the assessment. It's supposed to be both ways. We should be able to make submissions to the northern part, and the northern people should be allowed to make assessments, submissions here. The whole lot never happened, and the courts didn't want to know. And I put that before the High Court, Judge Barrett, and he didn't want to know. That's the hard fact. Now, we're now on 17. We're now going to look at Article 738. Now, when you go into the articles, you're into the better law. Now, the point I'm making, what I'm after writing about this waffle, and I think I'll go over it again for you. The correct and coordinated implementation of the SCA directive and all the other directives should should ensure the harmonisation of the main principle of the assessment of environmental effects, including the cross-border context. Member States should coordinate their assessments for projects of common interest and provide for joint assessments where possible. Member States should be encouraged to exchange the best practice and administrative capacity for permit building. That wouldn't last 5 minutes in the European Court of Justice. That's waffle. You have to do the SEA for the National Renewable Energy Action Plan and all the grids and all the rest. And you have to do it for the wind energy, and you have to do it for the guidelines for the wind energy, and that has been ruled in the case C-2419. I'm being a bit of an old preacher man here. Doesn't matter. I get my job done here, and people will at least see what the story is. This is not something I want to be doing. But it was a great pity that this wasn't done. It's such a pity that these pylons, people will be looking at them for 100 years, and the whole things are illegal to start with. Now we're going to go to Article 7 here, and I might stop this just to dig it out here. Sorry a minute. Now I'm reaching my hand in there, and that's because the button for pausing it. In my opinion, a pause is a vital part. How could I make this video without a pause? And you can't get it on any of the mainstream camcorders, only on a cheap Chinese Abilai. So it's worked up to now. So now we're going to look at Article 7.4, and I'm going to read it to you. By the 16th of August 2013, the Commission shall issue non-binding guidance to support Member States. See, non-binding guidelines. Do you get this? I'll read that again. By the 16th of August 2013, the Commission shall issue non-binding guidance to support Member States in defining adequate legislative and non-legislative measures. What's a non-legislative measure? to streamline the environmental assessment procedures and to ensure the coherent application of the environmental assessment procedures required under Union law for projects of common interest. There's only one thing that they can do legally, and that's rule out the councils, the local councils. But by right they should put in some substitute measure. There should be some type of a separate section of Burplanola to separate or to fulfil the role that the missing councils are doing. Or at least there should have been a special aid to going to the High Court. There wasn't. But apart from that, here we have a regulation directing that there be adequate legislative and non-legislative measures. That's the same as the National Wind Energy Guidelines. They try to say they're not binding, that they don't have the authority to make them and all that. The Court of Justice has said, if you have the authority to make them, it doesn't matter a hoot whether they're binding or not. You expect to get away with no SCA by this waffle, by saying that these things are not these instruments are not binding. So they put in something about the design of the pylons or where they'll go to or what to do, and that's not binding. And then when it comes up to planning in the Hotel Kilmore, oh, it is binding. That's where they're caught. Okay, they can't do that. So the next thing is part 8. With regard to the environmental impacts addressed in Article 6.4 of Directive 92/42 EC, I think that's pollution control, and Article 7 of Directive 20 EC, projects of common interest, shall be considered as being public interest from the energy policy perspective and may be considered as being overriding public interest, provided that all the conditions set out in the directive are fulfilled. We'll pause there a second now, folks. Now, the Directive 2060 EC is about water policy, and the 192/42 is about fauna or flora or habitats. It's about habitats, okay. So, with regard to environmental impacts addressed in Article 6.4 of the Directive, that's the habitats, and 44.7 of the water one, projects of common interest shall be considered as being public interest from an energy policy perspective, and may be considered as being overriding public interest, provided that all the conditions of the directives are met. What they're saying there, that if it's proven that there's a species or some area of special interest or something like Dunaree Forest Park or whatever gets in the way, you can plough through it. You can plough through it because they say so. That's what that means. Article 7.8. To hell with them, is what they say. The Habitats Directive, which has been used to preserve all these rare species and all that, can go to hell. Just to read it again. The projects of shall be considered as being of public interest from an energy policy perspective and may be considered as an overriding public interest. And then they make the sweet bit, provided all the conditions set out in the directives are fulfilled. In other words, you plough it on and get it done. And then you say, well, you comply with the directives. The whole idea with the directives is that you do it first. And the thing is, they mention those two directives there. They don't suggest that you can override the SEA directive and they're caught there. They do not have the right to go there. The next thing we look at here is Article 9.4, and then I think that's we'll quit it then, and we'll leave it and come back again. Article 9.4, just want to read this. At least one public consultation shall be carried out by the project promoter, and where required by national law, the competent authority, before submission of the final and complete application file to the competent authority pursuant to Article 10.1. This shall be without prejudice to any public consultation to be carried out after submissions of the request for development consent. That means when you apply for the planning permission, you can make your submission, right? Now, submission and request development consent to Article 9.2 of the EIA Directive. Public consultation and inform stakeholders, keep them informed, and all this. More I'll waffle. Some reason for that. So what they're saying really is they're talking about, they're more or less saying, as Max Barrett said, that the planning authority have to grant permission. It's public priority. They can't do that. They can't do that. That's beyond the powers of the EU Commission. They have to do the SEA. They're talking only there now about the EIA. They're talking about the EIA. This is the SEA. So that's it there. Now I'll probably come back to that to dwell on this a bit more, and that's it. That's all you want to know. The PCI is the European Commission deciding they can bulldoze the pylons through the whole lot, and they're caught on the SEA directive, the ESPO directive, and all the rest. The problem is we're out of time for taking a judicial review. I tried it. I hadn't the wherewithal to go on to the Supreme Court. It is not easy on your own with 7 barristers keeping notes and no one to help you hardly at all. I had a friend of mine that did give me a bit of help, but I had no note taker or nothing. So, and the time was against you, and I had to run my farm and all in the meantime. So that's basically the situation there now at 25 minutes. I've dealt with it now on that, and I'm going to come back now and try and put a bit of a liquor of paint on it too, so that you'll understand the whole lot what's at stake here. And I might actually do that now when I'm in the mood and get it done. So we'll see you back now in a minute, okay, or whenever.